So it may kindly be taken up next week, Your Lordship, please.
All right, item number 2 on the prayer of learned counsel. We are for the
I am for respondent, in fact, actually.
for the respondent number so and so, with the consent of the petitioner side. This is the matter again the next week.
Much obliged, Lordship.
Yes.
Lordship, may I seek Lordship indulgence in mentioning part 2, item number 10. My Lord, can we have it on this coming Thursday?
This Thursday.
Thursday,
Okay. Item
10, part 2, item 10.
Okay, you can, we need not pass any order. If it comes up, we'll pass over Thursday.
Oh, highly obliged.
Obliged, Lordship.
Daily list for motion, item number 1.
May it please your Lordship. Lordship, it seems we haven't complied with the direction regarding service of notice, so due to some communication gap with the petitioners. So Lordship, may we please be given time to serve notice to the respondents.
Where is it listed for motion again? You're for the petitioner.
Yes, my Lord.
It had for the petitioner. It is submitted that steps are yet to be taken pursuant to order dated 26/2/26. Petitioner is granted further 1 week's time to take steps. List the matter again on next week. Give a date. Yes.
Obliged, my Lord.
18.6. Item number 2.
Yes.
Your Lordship, my senior Miss Mary is on legs. May this matter be passed over for the time being?
What is the matter here for now today?
Yes.
For admission.
No, my lord. Case record has been called in the last court order.
Pardon?
This is a criminal petition.
Uh,
And my lord, in the last court date, we had hearing. And however, my lord, a TCR was called for.
yes, it's not come.
It has
Come.
come.
Okay, passed over for the time.
Item number 3.
Your Lordship, Your Lordship, in this matter, we will be filing show cause within this week. Show cause reply for respondent number 4.
For 3, it has been filed already.
Respondent number 3 has already filed.
I've heard learned counsel for the petitioner. Affidavit on behalf of respondent number 3 has already been submitted. Learned counsel appearing for respondent number 4. Praise for time
Yes, Your Lordship, within this week.
to file affidavit. Notice on respondent number 1. Service report, sorry, in respect of respondent number is 1 is still awaited. What about implement of new incumbent as a respondent number 5?
My lord, I have taken necessary step. I have served notice to the present incumbent. I'll be filing this week.
It is submitted on behalf of the petitioner that steps have been taken towards implement of the new incumbent and notice has been served upon him. And type of implement application, if necessary, shall be submitted thereafter. Full stop. Hence, list the matter again after 2 weeks.
Obliged.
Give a date, okay?
25th. Item number 4.
My lord, in item number 4, I'm appearing for the state respondents 1 to 4 as well as the private respondents 6 to 36. My lord, may I seek another 2 weeks' time to file my affidavit in opposition? I have not received any borough-wise comment yet.
You have not received what?
Borough-wise comments from the department.
It heard counsel for the petitioner. Affidavit on behalf of respondent number 5 has already been filed. It's Linda, learned counsel for respondents number 6 to 36. 6 submits that para-wise comments are yet to be received and seeks further time to submit affidavit. Prayer is allowed. List the matter again.
Lordship, if I may make a submission,
Yeah.
we have a prayer for interim order for stay of the impugned order. So if this may be granted until the disposal of the writ petition.
What is the interim order you were seeking?
It's the office order dated 21/8/2025. It's the notification for regularization of the private
Just
respondents.
a moment. For that, we'll have to hear the matter
Yes, ma'am.
for entry. Okay, let's have it then listed in the next week since there list it on next Thursday. Maybe by that time, at least you will have the instructions so that we can consider the list the matter again on next Thursday. Okay, the prayer for
Next Thursday, ma'am.
interim order will be
18/6.
taken up on the day.
Item number 5.
May it please the
Dusty, you
Lordship?
have done.
Yes, Dusty was completed on 30 March 2026, my lord.
Affidavit.
Yes, filed on 33.
You are appearing?
Lordship, I'm appearing on behalf of respondent number 1. I will not be filing our affidavit.
For respondent number
1.
1 only.
Yes, my lord.
What about 2 and 3? Our learned counsel for the petitioner has submitted that
Yes, Your Lordship.
dusty service has been affected and affidavit in this regard has also been submitted. Where is your affidavit? Could you serve or not?
Yes, my lord.
You served?
Yes, my lord.
Hence, service on respondent number 2 is
4, my lord.
4 is deemed to be complete. Is complete, not deemed to be complete, is complete. What about 2 and 3?
Yes, Your Lordship, I'm appearing for respondent number 2 and 3. And I'm seeking another 2 weeks' time to file my affidavit.
So and so appears for respondent number 2 and 3. And so for respondent number 1. And further time is sought on behalf of the said respondents to file counter accordingly. List the matter again. How much time?
2 weeks' time, Your
So
Lordship.
2 weeks. Isn't it?
25-6.
Obliged.
Item number 6.
My lord, in item number 6, paper book is received and a notice upon the informant is already effective. So I think it can be fixed for hearing.
Lordship, in the last court order dated 11/5/2026, I was allowed to file an additional affidavit to explain the delay between 8/8/2024 to 16/4/2025, Lordship. Then I have received the relevant documents from the department, and I may be allowed to file the additional affidavit within 3 days.
You have received the
Lordship, yes,
documents?
I've already received. I'm compiling.
I'd learned counsel for the appellant as well as learned counsel for the respondent, sole respondent. Learned counsel for the appellant submits that the documents, relevant documents have been received and accordingly seeks further 3 days time to file affidavit explaining the delay in preferring the instant appeal. Prayer is allowed. List again. Good. Today is Monday. When? Thursday.
Thursday? It's all right.
11:6. Item number 8.
Yes, respondent 2 to 5. Objection. As per office note, you are supposed to file UFO 2 to 5. Audio.
Yes, Your Lordship. I'm appearing on behalf of Miss Caroline. So she instructed me that she will be filing her affidavit, her objection.
What is the IA for?
This IA we are seeking for a continuation of 295, I believe, my lord. 295 days. A delay of 295
Delay?
days. Yes, my lord.
Okay. There is only one respondent, it seems.
There are 6 respondents. 1 and
Your
6 are
petition?
private. Private respondents, 1 and 6
Oh,
and
this is
2, 3,
regarding
4.
only service of notice. All have been served.
Yes, service completed, my lord. We have done the newspaper publication also, my lord. But till today they had not appeared.
You are for whom?
For the
Respondent?
state,
Huh?
for the state respondent, for the state.
State respondent only.
Yes, Your Lordship.
Okay, heard learned counsel for the petitioner. Stroke applicant stroke appellant. And so learned counsel appearing for the state respondent. That is respondents number
2 to 5.
2, 3, 4 and 5. Okay. As far as respondent number 1 and 6 is concerned, it appears that pursuant to orders passed by this court, attempt was made to effect dusty service, but the said respondents could not be located, and hence dusty service could not be effected as per affidavit. filed on behalf of the applicant. Subsequently, newspaper publication has also been made. When was that newspaper? On 9/12/2025. But till date, no appearance has been made on behalf of respondents number 1 and 6. Hence, service is deemed to be complete in respect of the said respondents 1 and 6. Yes, any objection?
Your Lordship, this matter is handled by Miss Caroline. So at the moment she is in court number 1.
Okay,
So I'm not sure whether she will be having objection or not.
All right, list the matter again in the after 2 weeks, give a date. In the meantime, the state respondents may file objection if any.
25/6.
Obliged.
Obliged, my lord.
Item number 9.
Lordship, TCR has been received and paper book may be prepared, my lordship.
Heard learned counsel for the petitioner and learned counsel for respondent number. Sole respondent.
Yes, sir.
The TCR has been received. Hence, registry is directed to prepare the paper book. List again after paper book. How many? 4 weeks?
Just 4 weeks.
All right, 4 weeks. At the cost of appellant.
My lordship.
13 of July.
Huh? Paper
Yes,
book
yes,
is to be
yes,
made at whose
the,
cost?
yes, at the cost of appellant.
At the cost of the appellant.
Item number 10 to 11.
Your Lordship.
My lord, in this matter, we have issued notice to the respondent by way of Talabana on 9/3/26. At this stage, my lord, no ID card has returned nor unserved notice, so we may await service report.
In respect of which respondent?
Sole respondent. He was the accused in the trial court and he was acquitted. And
Okay. The state is preferred this appeal.
Yes, my lord.
All right. Heard learned counsel for this appellant. It appears that notice on the sole respondent has returned unserved due to insufficient address. Applicant stroke appellant to furnish full and complete address and take fresh steps for service of notice. List again on
29/6. Item number 12.
My lord, in this case, we are, for the respondent, we have filed a written objection.
this is for I is for what?
On donation of delay, of 156 days delay.
Only.
Yes.
So what is the ground?
Lordship, in this case, the main issue was that
the applicants were not aware of the fact that the impugn order had been passed.
Why, it was expertise?
Yes, Your Lordship. It was a probate of a will. So it was not ex parte, it was done without giving notice to the applicants. And they only
Probate
came
of
to-
a will or it's airship certificate?
probate case, Your Lordship.
Probate.
And they only came to know about it in the month of December of 2025. And thereafter, when they came to know about it when the respondent attempted to evict the applicants from their home, saying that the will had been probated. Thereafter, documents were applied for and the instant appeal was filed in the month of January. February, Your Lordship.
This is the impugned order at page 9.
Page 9 of the condemnation of application, Your Lordship.
Yes. So no opposite party was there.
No, Your Lordship.
Who are you?
I am the children of the H. Lalkong Aliana. We are the...
Who? The testator?
Yes, Your Lordship.
The person who died?
Yes, Your Lordship.
You are his children?
Yes, Your Lordship.
And who is in whose favor has the probate been granted?
I am the present wife of the
present
deceased.
wife, yes.
Not
They
their
are-
mother.
Yeah.
Not their mother.
No, no.
They are my stepdaughters from the
Yes.
previous marriage.
Yes.
So I am the present, I'm the wife of the deceased Israel Kongoya.
And you did not make them a party.
No, they were not made a party in the
Probate
trial
case.
proceedings.
So then it is presumed they would have no knowledge.
They did not have any knowledge, Your Lordship.
The objection which we have raised by our written objection is that they have not given any sufficient explanation with regard to the dates when they had met their lawyers. They have filed a review petition in which they were also aware of the will which was
So the review
executed.
petition is with a different issue. It is not with the probate case.
So a review is also pending.
No, Your Lordship.
it was disposed.
Airship certificate was applied for and a review was filed and review was allowed. Airship certificate was set aside. Airship certificate was filed by the respondent and a review was filed against the impugned order in the airship certificate and the airship certificate was set aside. Thereafter, both
No,
parties-
as against the order impugned in this appeal, any review is there?
No.
Not against this order?
No, it was set aside already. Airship was first applied by the
No,
respondent.
we'll go to the airship later on. First,
Yes,
this
yes.
probate of the will was allowed.
With respect to this will, only this applies.
That order stands
Yes,
naturally.
that was
Otherwise, they
challenged
would not
before
have been in appeal.
Correct. That was challenged before this court.
You filed your objection, but there is nothing to show they had knowledge. They had knowledge of the will, but not about the probate.
Correct. They have known about the will, but not the probate.
Yes. So after that, the delay is not inordinate, is it not?
Yes.
All right. Had learned counsel for the applicant is IA 35 of 26. And learned counsel for the sole respondent. This IA has been preferred seeking condonation of delay of 156 days in preferring the connected appeal against the impugned order dated 10/6/25 passed by the learned civil judge senior division in probate application number 1 of 2025. Full stop. By the said order, probate was granted in respect of the will of the deceased in favor of the present respondent. Para. The grounds stated in the instant IA explaining the aforesaid delay have been perused. Para. Therefrom it appears that the applicants were unaware about the impugned order dated 10/6/25, inasmuch as they were one appellant or more.
Three appellants.
They were not made parties to the probate proceedings. Full stop. It is stated that the knowledge of the same came to the applicants sometime in the month of December 2025, when the respondent allegedly claimed that the property in question has been mutated in her favor and she attempted to take possession of the said property. Full stop. The subsequent period of about 1.5 months was taken up in the process of obtaining certified copies and consultation with advocate, as well as for preparation of the memo of appeal and connected applications. Full stop. Para. An objection has been filed on behalf of the sole respondent. Full stop. Learned counsel in the course of hearing has fairly submitted that the applicants did not have knowledge of the probate proceedings since they were not made parties. Para. Having regard to the grounds stated, I am of the view that the applicants were prevented by sufficient cause from approaching the court within the period of limitation prescribed by law. Accordingly, the delay in preferring the connected appeal is hereby condoned and the IA stands disposed of. Release the appeal for admission in the next week.
Right.
TCR may be called, my lord.
That will be in the appeal
Yes, my lord.
when it is listed.
My lord.
Next week, give a date.
18/6.
Any Passover item was there. Is it there? No. Nobody is there. She is not here. What was the matter?
Well, hello, the matter is about a release of a currency, a seized currency.
Oh, acha, that matter.
Your Lordship, in the last court date, you have expressed your opinion that money should be released on the bank guarantee given to them. Bank guarantee furnished by them.
So you are agreeable to release the money for bank guarantee?
Yes, against a bank guarantee.
Then we need not go through all this. All right. All right, we'll pass orders then.
Oblige.
And Your Lordship, we are ready for hearing item number 1.
Which one?
This is with regard to service matter.
Okay, we'll come back.
Yes.
Please proceed matter. Bail hearing, item number 1.
May I please, Lordship?
Yes.
Lordship, there is a case, my lord, the petitioner on 11/2/2026 was nabbed with intermediate quantity of heroin of 11.76 gram. Now, afterward, my lord, the case was registered under section 21B of NDPS Act, that is connected with the intermediate quantity, not commercial quantity. Now, in course of, my lord, this detention, my lord, I have completed the investigation and afterward also submitted the charge sheet. Now, while the charge sheet was submitted, the charge was also framed, and my lord, now on 18/6/2026, the matter speaks for, my lord, evidence of the prosecution side. Now, Lordship, here is a case 2 or 3 points I would like to urge before Lordship. First thing that, Lordship, so far this, my lord, intermediate quantity is concerned, it is well defined under section 21B. And, my lord, intermediate quantity has distinction with, my lord, commercial quantity, that is now defined in section 21C, my lord. Now, in this situation, my lord, what happened? Honorable Supreme Court has pointed out one judgment on last occasion I have given, that there is a distinction even in case of granting of bail of a small quantity and commercial quantity. It has to be looked into from the different parameters. Now, second aspect of the matter, Lordship, kindly see that so far the present petition is concerned, my lord, he is a local resident. Now, my lord, because of financial hardship or whatever reason, my lord, I admit that he has committed wrong, my lord. There is no doubt to that effect, my lord. But his entire family has a long, my lord, antecedents of that, my lord, of that Norway town, my lord. The father is a vegetable seller, my lord, and, my lord, the petition itself is, my lord, suppose married wife and, my lord, 2 children are there, my lord. Now, under these circumstances, anything, my lord, because of some, my lord, wrong guiding or whatever, my lord. Now, he has been trapped with, my lord, this quantity, my lord. But, Lordship, he has already learned the lesson, my lord. And so far, this, my lord, present position is concerned, my lord. Question doesn't arise that he will commit the same thing in again and again, my lord. Question doesn't arise, my lord. Now, another aspect, Lordship, kindly see, the whole issue is about, my lord, right to defense. Lordship, it is settled position of law, my lord, in order to defend, my lord, of one's case, my lord. If there is a possibility, my lord, then persons should not be deprived from getting the right to defense, my lord. Lordship, kindly see, the middle stage now, the prosecution is now, my lord, lying at the evidence stage, my lord. If suppose I would be in jail, my question doesn't arise that I can consult with my advocate or, my lord, place my case to the, my lord, in a right perspective, my lord. Under this secondary, the issue of right defense is also very pertinent. Now, another, Lordship, kindly see that so far the mother is concerned, Lordship. No doubt, it is not much relevant for this purpose, just to point out, my lord. Because, my lord, we are now just before Lordship to, my lord, pray our mercy, my lord. Let a chance may at least given to the persons concerned. His mother is now suffering from, my lord, very serious disease, my lord. Now, my lord, the verge of, my lord, this stage, if suppose at least one chance will be given him to suppose meet with her mother, my lord. My lord, I think humanitarian ground will also, my lord, plays a role to certain extent, my lord. But the thing is that, my lord,
who is suffering?
For a moment.
Who is suffering
One
from
judgment,
disease?
my lord, on last occasion I have placed. That is, my lord, 2010 3 SCC, criminal 793. That is, my
No,
lord,
who is suffering from disease?
Central Bureau.
Is it not one way?
My lord, paragraph 12, my lord, may I read?
No, am I audible to you?
Yes, my lord, absolutely.
No, who is ill? Who is suffering from disease?
Citation, my lord, 2010.
No, who is suffering from disease? Who is ill?
My mother.
Mother.
I have given the medical documents, my lord.
Urmila.
Yes, my lord. But there is a serious disease with that lady, my lord. Now, Lordship, we can only pray before Lordship that at least one chance may be given him to, my lord, get out from that, my lord, with any stringent condition, my lord. And he will appear each and every date of the proceeding, my lord, without any fail, my lord. If any fail, my lord, then, my lord, Lordship may take any stern action against him, my lord.
What is your citation?
My lord, citation, Lordship, kindly have 2010 3 SCC, criminal 793, paragraph 12. If Lordship permits, may I read the paragraph, my lord?
Yeah.
However, a distinction even is made as regard to grant of bail in relation to commercial quantity and small quantity. Commercial quantity has been defined in section 2 within bracket 7A of the Act to mean any quantity greater than the quantity specified by the central government by notification in the official gazette. Now, in the light of this paragraph 2, my lord, it is now settled position that, my lord, it cannot be equated with the provision, my lord, which is applicable in case of commercial quantity attracting, my lord, section 37, my lord. The section 37 at least transaction.
I think we are agreed on that much.
My lord?
I think we are agreed on that much. No citation is required.
I am just taking my lord plea, my lord, nothing, my lord. Lordship is well aware of that, right? Therefore, Lordship, I am not taking any other technical plea or whatever, my lord. My only humble prayer that, my lord, 2 count, my lord, which is based on genuine, my lord, cause, my lord. First thing, my lord, he is a local resident. I had discussion with his father.
What is the period of custody?
My lord, 11/2026, more than 120 days, my lord.
Yes.
Now, Lordship, so far, my lord, Lordship, one thing is very important. Suppose this kind of person, if allowed to free, my lord, sometimes, my lord, it become more danger for the society. Suppose they repeat the same thing, and my lord, it become more, my lord, suppose serious situation, my lord. But here is a case, my lord, if we go to the background of that person's, my lord, who is now involved with this case, my lord. My entire family are the local resident of that family since long time, my lord. Now somehow, my lord, because of financial hardship or whatever, misguided by someone else, my lord, now he slipped from, my lord, the actual position, my lord. Now involved with this kind of position, my lord, person. Therefore, Lordship, what happened, Lordship, my lord, mercy is always on the top, my lord. If Lordship give at least one chance, my lord, let us see if anything happened wrong, my lord. Immediately, Lordship, he may be called back, my lord, within custody, my lord.
Yes.
That is my lord, the basic submission, my lord.
May I please, Lordship?
Yes, prosecution.
So here in this case, Lordship, that material has been recovered from him, Lordship, and there is no any controversy also, Lordship. But Lordship, only because of right to defend, Lordship, he is seeking bail. Lordship, right to defend, only because of right to defend, and if every person is seeking that right to defend, then Lordship, the entire trial will be hampered, Lordship. And there is every possibilities of hampering and tampering of witnesses also, because no witnesses has been examined till late, Lordship.
Lordship, give us any condition, my lord, any single instance happened, my lord, I admit, my lord, he should not be allowed to remain outside of jail, my lord. Even he will not leave the location, my lord.
Yes. That is all?
Lordship, yes.
All right.
We'll
pass all right.
Eyes all bench. Hearing list, item number 1.
May I please, Your Lordship? My Lord, the reason of filing the instant petition is the petitioner was put under deemed suspension for about 2 years, 2 months, and 29 days, even after amendment of Rule 10 of CCA 1965, because as per amendment of the said 10 rules, no suspension or deemed suspension shall be valid after 90 days until and unless the said suspension or deemed suspension is reviewed or extended by the authority competent to do so.
You were first suspended in 99.
My lord.
16 to 99.
My lord.
Then proceedings.
Yes, departmental.
Then 2002 you were removed.
My lord.
Then 2008 is High Court order.
Yes.
Then reinstated immediately.
Yes.
Okay.
Then we were placed under the deemed suspension.
That is in the prior period.
My lord, yes.
Subsequently, you were removed again on 13.
My lord.
Okay.
Then
you filed representation. You filed representation.
My lord, with regard to that excessive deemed suspension, that by the order of this honorable court, representation was filed way back in.
No, what happened after 2013, 25 to
20,
2013, you were removed from service.
My lord, writ
After that?
petition. Writ petition was filed, and
No, that was beforehand.
yes, before after my removal, I filed petition and I was brought back to service. And the novo trial was held.
Look at your list of dates and events. See.
Yes.
So High Court order is of 3/7/2008.
My lord.
Is it not?
Yes.
Is there any other writ petition after that?
Yes, after that, the writ petition was filed by the petitioner. After he was removed from service in 2013.
But you have not mentioned it. The list of dates is itself not complete then.
Then I was removed by the DGP and without daring to.
Where is the subsequent order? You say you filed a writ petition. Where is the order passed in that writ petition?
My lord, in my
I don't find mention of two writ petitions in your petition itself.
that writ petition with regard to removal is not annexed in the instant case.
So what order was passed?
That order is that petitioner be reinstated with liberty to file, with liberty to hold de novo trial with regard to proposed punishment. And
where is that order? Order is dated.
Order is not,
you have come with incomplete facts. That means
that order is not annexed in this case.
Then neither have you stated about the second writ petition, nor have you annexed the order. What are we going to make of it?
This writ petition is fourth one.
Where have you stated all this?
The third writ petition, order of third writ petition is annexed at additional affidavit filed by the petitioner at page number 13. Additional affidavit. My lord, in my additional affidavit, affidavit annex as annexure 1, page number 6. This is the second writ petition filed by the petitioner. Date of judgment 28/6/2016. Annexure 1, page number 5, WPC number 93 of 2015. This relates to the petitioner herein.
So page 13 is the third writ petition.
My lord.
Yes. And after that,
This one.
which order?
Annexure 2, page number 13 is the third writ petition, giving liberty to file representation to the competent authority. And pursuant to the said order, representation was filed, but the same was not allowed. Hence, the instant petition.
No, after the order dated 23/4/2018,
Hello.
what was the next thing that happened?
The next thing is
The direction was to the authorities to consider how the period of suspension is to be treated.
the petitioner filed representation dated 4th October 2018, Annexure 6, page number 69 in the instant writ petition.
Yes. And after that,
Vide Annexure 7, page number 72. My
Yes.
representation was rejected.
so what is the basis of your claim now? What is
My
the
lord, at this stage,
infirmity in this order?
my lord, that order based on FR 40 54
Yes.
54 sub rule 5. May I read?
Yes. Effort.
In a case falling under sub rule 4 above, the period of absence from duty, including the period of suspension preceding his dismissal, removal, or compulsory retirement, as the case may be, shall not be treated as period spent on duty unless competent authorities specifically directs that it shall be treated for for any specific purpose, provided that if the government servant so desires, such authority may direct that the period of absence from duty, including the period of suspension preceding his dismissal, removal, or compulsory retirement, as the case may be, shall be converted into leave of any kind, due and admissible to the government servant. So this one proviso is not open to the petitioner.
No, where is your desire? Did you file any application for treating it as leave?
No.
Then?
My lord, one more thing. This when the petitioner was reinstated by the authority concerned, an order was made that the period between his suspension, yes, my lord, Annex 4, page number 63 of this writ petition. Page number 63, Annex 4, third para. However, the suspension period till reinstatement will be decided on merit of the finding of the DE instituted against them, as and when the EO submit his findings. Whether he found the petitioner guilty or not is one thing, but period of absence, when was not discussed when the petitioner was brought back, when the petitioner was removed from service by order dated 31st August 2016. This order, Annex 5, page number 64, 31st August 2016. No such mention was made by the authority.
So now it has been made.
My lord?
Now it has been made.
But in that regard,
that is the
the
reason
whole of
that was not made. So
Yeah.
that was in 2010.
it is the fault of the authority concerned, and the petitioner who and the petitioner cannot suffer the fault of the authority concerned.
Now we'll go there later. First, let us be clear with the facts. So, after that, this final order was passed. This is the Annexure 5, 31st of August 2016, right?
Yes.
So after that, you filed writ petition again.
My lord.
So their writ petition was disposed of with direction to the authorities to consider that. And after that, the impugned order has been passed considering that. How can you say that that aspect is not considered? No, it has been considered as per direction of the court. They have not dealt with how to deal with the period of suspension. They have referred to FR 54.5, with which you apparently don't have any quarrel, As far as the proviso is concerned, for that you have to file an application, which you have not filed. So what is the infirmity on the order?
Well, a door was not open with regard to extension of proviso thereon. The petitioner was not offered this proviso, whether to adjust his absence for leave.
And I don't think any leave will also be available for you. How long is the period of suspension? Cumulatively, it will be 11 years. Then, what leave will survive?
My lord, the petitioner was put under deemed suspension for 2 years, 2 months, 29 days, which he is not at fault. The respondent who failed to adhere to the amendment of Rule 10 of the CCA inflicted this kind of indirect
Filing this
punishment to
writ
the
petition,
petitioner.
you should have filed an application to treat that period of suspension as period of leave as per proviso to this sub rule 5. Yes, Miss Mary.
Yes, Your Lordship. First of all, if I may take Your Lordship kind attention to the prayer portion. My learned friend have made a prayer only with respect to the impugned order dated 20 March 2019, which is in Annexure 7. Now, Your Lordship, this is an order of disposal of representation that is submitted. Now, it is a settled principle of law that without challenging the actual order, challenging the consequential order will not have any value, Your Lordship.
Your orders have already been challenged.
No, Your Lordship, 2018. This is the outcome. This representation is the outcome of the 2018. 2018 order is in page number.
Order of?
The order of the DGP. Ano yun pa? (2018)
2018 DGP order.
It's order of removal, Your Lordship. Sorry.
Page?
Order of removal is 31st August 2026, Annexure 5. Page number 61. This is order of removal. That's my learned friend have not challenged, Your Lordship, in the prayer portion. Now, what he have challenged 2019 is only the consequential order, Your Lordship. He did not challenge the principal order.
Page 61 is only a suspension order.
64. 64.
This is 2016 order.
2016 order. Wait.
64 is 2016 passed by IGP.
Where is the removal order?
This is the removal after the High Court directed de novo, isn't it?
Yes. Wait, I have. Anyway, Your Lordship, I will come back to this. But what I would like to submit is that from the order of 2018 20th March 2019, we will see that this is only the consequential order. We can see it from the first line, in page 72. The petitioner Lil Sanglor SI oblique M retired submitted a representation. So this is only a consequential order that is being challenged.
Naturally, he has filed a representation. On his representation, an order has been passed which doesn't suit him.
Yes,
That
but
is what he will challenge.
there is a settled principle of law in service jurisprudence that if you do not challenge the principal order, then
Which order you were unable to point out?
I will
And you were insisting for hearing.
Yes, Your Lordship, I was okay. It's in my affidavit. It's in my affidavit, annexure 12. Annexure 12. Starting from page 45. This is an order dated 23rd July 2018.
Order dated
23rd July 2018.
that is not in the writ petition.
Yes, it is not in writ petition. So that is my other point. My first point is
Just
not
one
challenging the principal
Just
order.
one moment.
Your Lordship, if I may take Your Lordship kind attention to the page number 50. Whatever I am relying on is mentioned here in this order.
Yeah, according to you, the original order which they should have challenged is dated
23rd July 2018, as well as the order of removal, which is the order dated 31st August 2016.
There cannot be two original orders.
But my learned friend have challenged only the 2019 order.
That's not the question. My question is, which is the original order? How can there be two original orders?
Your Lordship, 2016. 2016 is the removal order.
Date?
Date is
Which according to you is the original order?
2016, Your Lordship.
Yes.
2016, it's in annexure. 31st August 2016, which is in page number 64, annexure 5 of the writ petition. And subsequently, an order representation was submitted, and it was disposed of by my 23rd July 2018, which is annexed in my affidavit as annexure 12.
No, according to you,
According to me,
the order dated 28/6/2016.
Your Lordship, according to the facts of the case, 31st August 2016, he was removed from service. This is the original order which needs to be challenged. In the prayer portion, it has to be mentioned. And then there is also a subsequent order which I have pointed out from my annexures in my affidavit in opposition, that is order 23rd July 2018. Now, this is a disposal of the representation that it was submitted after, after,
Just a moment, where is 23rd July order?
it's in my affidavit in opposition, annexure 12.
Where is your affidavit in opposition now? By state respondent, okay. Annexure 12.
12. Your Lordship, let me rephrase my submission. I think it's a little bit shabby. Page 45. Yes, Your Lordship. Now, referring to annexure 5 of the writ petition as well as page 45 of my affidavit in opposition, let me rephrase my ground. Your Lordship, after third reinstatement of the petitioner, order dated 31st August 2016 was passed by the concerned authority. Now, against this order dated 31st August 2016, representation was submitted by the petitioner and it was disposed of by order dated 23rd July 2018. And after that, a subsequent representation was submitted by the petitioner, which my learned friend has impugned in the prior portion, Your Lordship. So my case is that there are the principal documents that needs to be challenged is 31st August 2016 as well as 23rd July 2018, because in the prior portion what is written is that 2019 is only challenged. And supposing if my learned friend have said that in the writ petition he have mentioned that impugned order dated 31st August 2016. Now, even if presuming but not admitting that that is allowed, this 23rd July 2018 order still stands, which is not included in the petition at all. Now, without this, Your Lordship, there cannot be a full-fledged scrutiny of the documents or the case. That is my first point. Not challenging the principal order and the subsequent orders. Now, my second point is that, Your Lordship, with regards to the writ petition, it is the duty of the petitioner to place all relevant documents before this honorable court, which they have failed to do so. It's like they are playing hide and seek. And that is my second point, Your Lordship. Failing to appear before this court in clean hands. And third point is the limited scope of this honorable court in entertaining this case, Your Lordship. Your Lordship, in this regard, I would like to refer to 2013-14 SCC 379, paragraph number 11. This is the case of R. Mahalingam versus Chairman Tamil Nadu Public Service Commission and another. Paragraph 11. It's in page number 390, Your Lordship. With your lordship permission, may I read? We have heard the learned counsel for the parties. The scope of judicial review in matters involving challenge to the disciplinary action taken by the employer is very limited. This is number one. The court are primarily concerned with natural justice has been followed, which is done in our case. Second is that the court can also consider whether there was some tangible evidence for proving the charge against the delinquent, and such evidence reasonably supports the conclusion recorded by the competent authority. This is not the case of the petitioner in our case. So number two also done. Number three, if the court comes to the conclusion that inquiry was held in consonance with the prescribed procedure and the rules of natural justice and the conclusion recorded, then there is no scope for interference with the discretion exercised by disciplinary authority to impose a particular punishment,
He
except...
is not on the punishment. This is a case of interference with the order of punishment. He is not
Yes.
with the punishment. His removal he has accepted. He is only with the how the period of suspension is to be treated in terms of the rules.
Correct.
He is only on that.
Yes.
So how does this judgment become relevant?
Your Lordship, it is irrelevant as much as he was given out of compassionate ground. He was given compulsory retirement as a punishment.
That is
Now
not-
he
that has
is-
nothing to do with this judgment. That is a different issue altogether. You can say that he have been given compassionate appointment considering his case, not appointment, is so compassionate what allowance, not exceeding 2/3 of pension and gratuity.
Yes, yes.
That is a separate matter. That has nothing to do with this, how the period of suspension is to be treated.
So anyway, that is my ground, Your Lordship.
Yes.
And the third ground is no work, no pay, Your Lordship. With regards to the how to deal with that, 2005 8 SCC 247. Paragraph number 7. Your Lordship, I'm just going to take the ratio in this, that no work, no pay, because this factual situation is admittedly not in line with the current the case in hand.
Yes, after, no work, no pay. After that,
Yes. After that, I would like to rely on my affidavit in opposition, Your Lordship.
no work, no pay. You cited something.
Yes, I have cited paragraph number 7 of 2005 8 SCC 747, page 750. I'm just taking the ratio, since admittedly the factual situation is not in line with the factual
If it is
situation of
period,
the case.
if the suspension is treated as period on duty, would he be entitled to pay for that period?
Your Lordship, what I would like to...
Or is it only for the purpose of calculation of pension?
No, Your Lordship, the logic, I'm just referring to logic of no work, no pay in this. The fourth line. this has related to
That is why we are precisely asking that even if it is treated as duty, it may be only for the purpose of pension,
yes,
not pay.
correct, Your Lordship. Your Lordship, and my
Anyway, we are not there yet. First, he has to satisfy how the order is wrong,
yes,
how the consequential order, as you call it, is wrong. If we find that it is wrong, then you can go to that he hasn't challenged the initial order. All no work, no pay, and all that. But first, he has to cross that hurdle. So, what is your submission on that?
my submission on that is, if I may take Your Lordship kind attention to paragraph number 11 of my affidavit in opposition, which is page number 7. Your Lordship, I have not put my citation of CCA rules 1965, but I think that it might be available.
Page 7 of your.
My affidavit in opposition, wherein I have elaborately explained my stand.
Para 11.
Para 11, page number 7, Your Lordship. Your Lordship, from para 2, second para, not 2, as per the provision of sub-rule source.
Yes, what about this CCS rules? Rule 10, sub rule 7.
Why not may read?
Huh?
May I
Yes, we have read that. We have this before us. What is government submission in this regard? We have your submission already on record.
Sub rule 7.
Yes, yes, we have heard that. We have read that. This is regarding validity of period of suspension.
Yes.
Your contention is that it was not reviewed.
My lord.
So it is the period is invalid.
Yes.
Suspension is invalid after that period.
Yes.
Yes,
After
what is your
90
response
days.
to that?
an order of suspension made or deemed to have been made.
No, just a moment. Let's get the response. We have heard your point.
Yes, Your Lordship. Admittedly, there was an excess days. It is mentioned in my affidavit also. Suspension period exceeding 90 days without review by suspension committee, mentioning that suspension period till reinstatement will be decided on merits of the departmental inquiry submitted.
Where are you reading?
I have read from para 10 of my affidavit in opposition, Your Lordship.
Yes, you were instated because the period of suspension exceeded, crossed the period of review. Thereafter, you were reinstated, and it is only after your removal that you were released.
Yes, my lord.
So
Initially,
that grievance is no longer there. Once you submitted representation that 90 days have elapsed
my lord,
and no review has been done, so you were reinstated at that
I
time.
was initially reinstated to service wide order dated 11th September.
Now you are telling all this
2008.
from memory and you have given this short a list of dates
My lord,
without mentioning anything about so many cases.
I made a list of dates, something here, something like notes.
Yes, submit that.
Yes. This amendment was published in the Gazette of India, notification 16 June 2007. Although Gazette copy is not annexed, and the same also is incorporated in Government of India Department of Personnel Training, dated 12 July 2017. Amended portion has been incorporated in this book called Swami's Annual 2007 Compendium of Orders and Service Matters 2007. Amendment portion of this one. Impugn order dated 31st August 2016, as well as a rejection order of my representation 2019 are also challenged, mentioning the same in the cause title of the case, as well as in my prayer portion to set aside in clause and so on.
Yes. Anything else?
So since the petitioner has no fault with regard to non-application of such elongated deemed suspension, the petitioner has no reason to suffer the mistake of the authority concerned, and the said period be considered for counting us on duty for any purpose whatsoever in the interest of justice, because the said periods, during the said period, the petitioner has no fault in that regard. The petitioner was put under suspension for 2 years, 2 months, and 29 days, but the petitioner has not contributed on the part of the negligence or non-application of mind on the part of the authority concerned.
Everything here is jumbled up. List of dates not tallying with one another. This is everything according to you?
Yes.
It is at your risk.
Yeah. Some are based on whatever is written in the annexure, and some are.
If you like, you can give a complete list tomorrow. We'll keep it part heard till tomorrow. Otherwise, we have heard you. If only for the purpose of giving a list, you can give. We can fix it tomorrow again.
My lord.
Your Lordship, I have some personal problem for appearance tomorrow because I have a doctor appointment.
No, you only give a list
Yes,
of dates.
I may be exempted to appear.
All right. Give a detailed list of dates,
Yes, I'll make.
including all the cases you have filed in the High Court, all previous 3 cases, everything. You can give the orders under. You can also annex the orders if you want, but if it is not already here. If it is here, you mention besides it that page number so and so of so and so. All right. Heard in part list again on.
Please, Your Lordship, with regards to part 2, item number 4 and 5, it's fixed for tomorrow, Your Lordship. So if you maybe pass over for the next day, Your Lordship. I believe that no item is fixed on Wednesday. Both I have taken the consent of the other parties.
4 and 5.
Yes, it's fixed for tomorrow.
Okay. Item 4 and 5. Wednesday.
Wednesday, 10th.
We don't know. Wednesday will be having division bench.
Any convenient day.
Let's see. We'll try. Okay. Let's keep it for Wednesday then.
My lord, one more thing. Part 2, item number 13, mock appeal. Both councils agreed to take up the matter this coming Thursday, if time permits.
Item 13.
13, before your lordship. Listed before your lordship. It will take 10 minutes, something like that.
Okay, no. I've written in my cause list, so no order is required to be passed.
Okay.
Give you all much.